Hello everyone, this is Yoko. On this channel, I feel that information about what is happening in China is often not correctly conveyed to countries other than China, so I will be disseminating the information I have gathered in English. I'm getting information from multiple media, so I'd be happy if you could comment on the content of the video. Also, my native language is not English, so I use an AI speaker to create the voice to convey the information correctly. If you like it, please subscribe to the channel and support us. This is a supplementary video to the video I uploaded yesterday, so if you are not interested, please skip it. Article 15 of the American Bankruptcy Code is a special law that is difficult to understand just by living a normal life. I think this is a very surprising law for people with zero knowledge of it. Actually, Chapter 15 has been used by Lucky Coffee before, but ordinary people probably don't know about Lucky Coffee. Some people may be wondering why bankruptcy proceedings in the United States, but Article 15 of the Bankruptcy Code is not a simple bankruptcy proceeding. This time, I would like to introduce the core of this story once again, emphasizing the important parts. First, let's talk about Chapter 15. Chapter 15 is a system of cooperation between U.S. courts, designated agents, and foreign courts when bankruptcy proceedings are initiated in a country other than the U.S. Importantly, Chapter 15 is not about starting bankruptcy proceedings in the United States. This assumes that bankruptcy proceedings have already begun in a country other than the United States. The idea that bankruptcy proceedings have started with this filing is wrong. But as a prerequisite for filing, bankruptcy proceedings must have begun in a country other than the United States. So, my understanding that bankruptcy proceedings have started is a bit complicated, unless I'm correct. Many people think that bankruptcy proceedings have started in the United States, but that is not the case. This means that bankruptcy proceedings have already begun in another country. So I am bankrupt. There was an explanation from a Chinese legal expert that procedures may have begun in Hong Kong. A Reuters article in Japanese reported that bankruptcy court filings seek approval for ongoing restructuring talks in Hong Kong, the Cayman Islands and the Virgin Islands. The Cayman Islands and the Virgin Islands are tax havens. There has been a pattern in the past of first completing the procedures in a tax haven and then applying in the United States. In the case of Lucky Coffee, I think it was the Cayman Islands. Corporate restructuring discussions are already underway in countries other than the United States. Since this is similar to bankruptcy proceedings, Article 15 of the bankruptcy law states that assets should not be seized in the United States. There is a reason why this special law was created. A Chapter 15 filing is based on the assumption that bankruptcy proceedings have begun in the multinational company's home country. It has a proper meaning. For example, suppose there is a multinational company named A in Japan. This company does business in various countries, and also has factories and subsidiaries in the United States. However, the company's overall business performance deteriorated, and the company was unable to repay its debts. As a result of the start of bankruptcy proceedings in Japan, the company will be liquidated, but the assets held by A's headquarters in Japan will be sold. However, this company is a shareholder in subsidiaries around the world, so for example, it sells its American subsidiary and distributes it to its creditors. However, when bankruptcy proceedings begin in Japan, American creditors file suit in American courts and attempt to seize Company A's assets in the United States. Then, American creditors began collecting their debts by selling American assets. If this happens, the amount that creditors who participate in bankruptcy proceedings in Japan will be able to collect will be reduced. If the company had not been foreclosed on in the U.S., it would have been possible to sell the stock in the U.S. subsidiary and have it distributed, but once the U.S. assets are gone, the amount that creditors can recover will be reduced. Some people think this is unavoidable, but Chapter 15 means that once bankruptcy proceedings begin in your home country, all creditors around the world should be treated equally and fairly. For example, if bankruptcy proceedings begin in Japan, a foreclosure in the United States will not be possible. By the way, preventing companies from being sued individually in each country is not just about ensuring fair distribution when liquidating a company and distributing it to creditors. Huge companies have many employees and many business partners, so they often try to rebuild the company rather than liquidate it. However, when individual lawsuits occur in various countries and the company's assets are lost, it becomes difficult to rebuild the company. This would be a loss to creditors. Originally, jurisdiction is extremely important for a nation's sovereignty, but the rule is that it should be emphasized with respect to the courts of other countries. This framework cannot be used if the other country cannot be trusted, as it has the meaning of entrusting part of national sovereignty to the courts of another country. Because of its historical background, Hong Kong is considered to have a fairly reliable legal system, but although it was once viewed as such, it has recently become questionable. If you go through bankruptcy procedures in a country with a Western-style legal system, such as Hong Kong or a tax haven, you may be able to use Chapter 15 in the United States. Whether it will be truly recognized remains to be seen. Evergrande has filed for Chapter 15, formally acting as a bankruptcy proceeding or a legal proceeding similar to a bankruptcy proceeding, but only a small number of interested parties are currently participating. Probably not. Some foreign creditors are carrying out some procedures in tax havens or Hong Kong, but the huge creditors in China may not be participating in those procedures. For example, it is said that the number of banks that lend money to Evergrande is in the 3 digits. However, if there was any talk of Chinese banks participating in corporate restructuring or bankruptcy proceedings in Hong Kong, there would be an immediate uproar. Therefore, if many creditors do not participate in the preliminary procedures necessary for filing a Chapter 15 application, it is unclear whether the application will be approved. I think there is a possibility that it will be rejected. There is another point to keep in mind when filing for Chapter 15. After filing for Chapter 15, Evergrande Group must notify its known creditors. In the case of Evergrande Group, the main creditors are within China. There are a huge number of creditors in China, such as Chinese banks and investment trusts, but the interesting point is whether they will come forward as creditors. One thing is clear, Evergrande Group is already in a terminal state. The business model of China's giant real estate developers is no longer sustainable. That's all for now. See you next time.